Good afternoon. I'm so glad you could join us today. Here at Ray Law Criminal Defense, our attorneys are consistently hard at work advocating for our clients. We believe strongly in the importance of knowing your rights. In today's topic, we look at the Confrontation Clause. Before we jump in, take a minute to hit that subscribe button. In our videos, we've spoken often about the process of standing trial as a criminal defendant. Paramount to that procedure is witness testimony. For more on the different aspects of witness testimony, you can check out the video links in our description. But today, we're going to focus on your right as a defendant to be present for testimony that is presented against you. That right is contained within the 6th Amendment in the U.S. Constitution by way of the Confrontation Clause. The Confrontation Clause states, "In all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him." This means that a criminal defendant must be given the opportunity to be present during witness testimony that supports a finding of guilt. The reason for this is twofold. The first is that it prevents a defendant from being found guilty on the basis of written evidence, which in some instances may violate the hearsay rule. And the second is it also promotes truthfulness on the part of the witness. The issue of truthfulness is rooted in the notion that basic human nature may make it more challenging for the witness to tell a lie about the defendant while being face to face with them. The Confrontation Clause also preserves the defendant's right to cross-examine a witness. It is impossible to cross-examine a piece of documentary evidence, or a testimonial evidence for that matter, if it is not being provided real time. For this reason, courts have held that an out-of-court statement cannot be allowed into evidence without the defendant's opportunity to hear the witness and cross-examine them about the contents of their statement. The supposed reliability of a witness doesn't matter. Not allowing for cross-examination is akin to doing away with the defendant's right to a jury trial, which is also guaranteed by the 6th Amendment. There are situations where courts will hold that the rights granted by the Confrontation Clause must be balanced against some alternate protection. A good example of this is when a minor is testifying in a criminal trial. In-court testimony may be overwhelming for a child. Allowing for a child to testify in real time via closed-circuit television is an alternative means to elicit testimony. It is an option that preserves the defendant's right to view and question the witness in real time, but also protects the child against the possible trauma of in-court testimony. Courts also look at whether the statement goes to prove a material issue of the case. For instance, a witness account that alleges the defendant's participation in the crime for which they are on trial is considered testimonial. The defendant should be given the opportunity to cross-examine that witness. However, a witness's intent at the time their statement was made is also an important factor to consider. For example, if a witness statement is being made not to incriminate the defendant, but rather provide information to emergency personnel regarding an active situation, it will more likely than not be considered testimonial. In that case, the Confrontation Clause won't apply. Now, if you enjoyed this criminal defense video, also check out our Ray Law Immigration channel. There, we'll keep you up to date on all the latest developments and drama relevant to the U.S. immigration and naturalization process. Have you ever been a witness in a case where the Confrontation Clause was an issue? Tell us your story in the comments below. Thank you for the privilege of your time. Until next time, please be safe out there.